before.
Yeah.
They didn't have them for like
Well, I lived in
forever.
New
Now they
Jersey.
don't.
I think there's a pretty
Yeah,
much,
they're shops. I'm like 68.
yeah. Some of them
Well,
are
that's how before my friend
fair.
never had to.
Yeah, oh yeah,
It's just like,
definitely.
should I laugh? Should I not laugh?
Yeah. I think I did a few waffle houses or something like that.
That's.
Okay, let's talk about the Americans with Disability Act, which is the next section on the syllabus. Let me just say, with the snow that we've been getting, obviously we lost last week, so we're gonna do this first section, all of it tonight, and then we'll do the business relationships on Thursday to try and stay with the syllabus. The problem is gonna be they're looking at more snow again. Within the next 10 days, I saw something that said might get another 2 feet of snow, so we have to try and stay on task here with the schedules, and it may come a time that we may just have to take the information and put it up so at least we don't fall further behind. So we'll take a look at this, and if we, depending on how this goes with respect to the snow and the like, we may have to adapt even a little further than we're going to. But this week, we are going to get these cases done so that we get back on track. The questions that are posted for the people online are posted along with the sections. The first grouping of questions were on the bottom of the syllabus on the very last page. They also have 103 questions, as you do, to submit to me that goes along with the PowerPoint presentation. And then shortly, within the next 3 weeks, actually, I will give you a fact pattern that you will prepare a complaint on that you can file in court. And until then, we just keep plowing ahead and moving along. And so the first thing I wanted to talk to you about tonight is the Americans with Disability Act. So we're going to look at a lot of traditional remedies when we think about remedies, injunctions, declaratory judgments, sort of the classic stuff. But we're also going to look at a number of different modern statutory remedies that are used quite frequently and that you need to be aware of. And a lot of the more modern remedies, like the ADA, also bring with it potential opportunity for attorney's fees and the like. So, I mean, these modern statutory remedies deserve a good look when you're starting to think about, well, what your client's rights are. And this is one of the things that you really should be aware of these days, because these potential cases are, whether you're going to be representing plaintiffs or small businesses or whoever, you should be aware of what the law is and what the consequences are. So, can someone tell me briefly what the Americans with Disability Act does do, if you were to sort of define it loosely for me as to what the requirements would be, basically?
Well, one of the things that prevents the employers from discriminating against employees who have a disability that affects it has to affect their day-to-day life. It has to be a substantial.
Okay, so you can't discriminate against people with disabilities.
And that disability has some pretty narrow bands in which it.
And by saying, oh, well, let's talk about that. What is a disability? Maybe that's the easiest probably way to start. What's a disability? Go ahead.
A physical or mental impairment that substantially limits one or more of the major life activities of such individual.
And what are they, when they initially were looking at this and trying to define it, so what do we mean by then major life activity? How major does it have to be, I guess is what I'm asking you.
It has to affect day-to-day normal tasks that people do, so.
But what's that mean? How do they define it? Like what?
Let me get,
Because we all, I mean, because I guess I'm thinking we all suffer from some level of disabilities, no?
they say performing.
I was never very good at biology. Is that a disability? Why not? Why not?
Because it's not something that's gonna be so life-changing. You might be good at mathematics or something else, so it's too narrow of an area to completely change your life.
So what is that? What is the disability? Go ahead. What's the disability? What does the disability have to be?
The court defined it as caring for oneself or in manual tasks.
Okay, so wait a minute. These are the major life. It must affect a major life activity, such as
manual task, walking, seeing, hearing, speaking, breathing.
Okay, slow it down.
Oh, I'm
So
sorry.
walking, talking, seeing, caring for oneself,
Breathing,
breathing. I mean, those are pretty major functions that it has to affect. No? So if just one arm is stronger than the other, that's not a disability? No? Walking, talking, seeing.
hearing.
What if, President Silber from BU, you guys are all too young at this point to know, but he had like one hand was much smaller, like Bob Dole's, was all shriveled up like from, I don't know, I think he was born with the defect. Bob Dole's was from the war. Would that count?
Maybe if it was the hand you wrote with.
Yeah.
But if it's not the hand you wrote with, even though you have, or you might be seen as having some limitations, that wouldn't count as a disability if you can walk and talk and feed yourself?
Not major.
What?
I don't think it's major.
So it's not major if you have overcome the limitation. Is that right? Go ahead.
It has to limit a major life activity.
Limit a major life activity. Okay,
A person who has a history of such an impairment, or a person who is perceived by others as having such an impairment.
so it's either they have a history of it, it does it, or perception?
Or what others perceive as a substantial impairment.
How does that work? Others perceive as a major impairment. So I look at you and say, disabled? I perceive you as such could count even? Or is that just for the discrimination part of it? Because remember I told you about Hans used to go around in the wheelchair schooling me at court all the time? The wheelchair was no limitation. It might as well have been a huge limo that he used to drive around in and beat my brains in frequently with. So is that though, is that what at least in part when they say perceive as a disability so that the employer can't discriminate against you should they think you have some type of disability? Because my guess is when we get to the next phase of this, there will be some employers that will want to say, well, I don't want to get involved in that. I don't want to have to lighten your load. I don't want to have to buy special equipment. I don't want to have to do this or that. And they might have to do some of those things. Is that true? So you said you can't discriminate against them, which that would be hard pressed for anyone to say, no, you should be able to discriminate against someone. No? But is that where it ends, or do you have to do more? I'm wondering, go ahead.
You have to make reasonable accommodations for that person with that disability.
So reasonable accommodations, and I think it talks about to qualified individuals, right?
Yes.
So reasonable accommodations to otherwise qualified individuals, the Americans with Disability Act requires. I wrote an article when this first came out called Civil Rights for the Disabled, because that's what, when the first President Bush signed it, that's the way it was pitched, is that it's supposed to try to equal the playing field a little bit for those with disabilities. Reasonable accommodations, that sounds like it could be problematic. I mean, even small businesses potentially are required to do this?
I think there's a threshold for like really small, I didn't see this in the cases that we read, but there's a threshold, I believe, for very small businesses.
Well, I mean, I don't mean mom and pop, so it's me and mom and an employee. I'm saying a small business would, because I could see some of these reasonable accommodations for a small business potentially being expensive. But, go ahead.
Like when when this was all coming out, you would have to make a wheelchair ramp, like if your business only had steps, you had to like make.
So in a physical location, you would have to make accommodations to the infrastructure potentially, like a ramp to be able to get access. What about a water fountain? I said bubbler over the weekend. Someone looked at me like bubbler, my Boston accent. What about a water fountain? Would I have to lower a water fountain so that it would be the height that someone could use it?
That's why they have the ones that one taller and one lower, right? I mean, that's probably.
So I would? That could be expensive, no? But is that a reasonable accommodation? So you come in And by the way, there are law firms, lawyers that specialize in this area and also look for opportunities because of the provision of attorney's fees to say that you're not compliant. So I might have to lower the bubblers, change the bubblers, widen the doorways. Would you, elevator?
Widen the doorways or install a ramp I'm a little bit more on board with, because, you need to do that to get into the building. And I would imagine things that are,
But you don't need a drink of water, Chris?
you could bring a bottle of water. I did.
Well, okay, well, what about that? I mean, I don't want to bring a bottle of water, I want to be able to use the bubbler like someone else.
I'm gonna stick your face in that disgusting. Yeah, that's.
Before you guys all got rich and carried around your water bottles, that is what we did, okay? We actually drank from those things. Because that seems like that's just the first road we're gonna start down. Oh, I can't hear that. I've got a hearing disability. I want special earphones. You gonna provide those for me? Is that reasonable? I mean, when you guys interpret reasonable, how far do we go? Because I want to talk about Casey Martin, obviously. Go
I
ahead.
think if you're looking at public accommodations, you have to have a certain balancing test to depend on fixing the problem of like fixing a bubbler against the cost, if that makes any sense. If you have a problem with the bubbler because it's not, if for whatever reason you have a disability and you can't reach that one, I mean, to fix it against you being discriminated against because of the bubbler, I think there needs to be a balancing test, what's important.
Well, help me with that though. Is so you could have a building that I, in my wheelchair, can't use, like you people who aren't in a wheelchair, and that's on me, not you. You shouldn't be required to comply with the law that says you must make reasonable accommodations for people with disabilities. I mean, okay, you're the one in the old building. It's not me. I didn't just choose to go here. The fountains don't comply, and we're gonna go down this road. I mean, if you guys are holding me out on fountains, there's a lot of other problems I think I should start to think about it. But the cost becomes a factor, right? But how much is the cost? Well, is that what will determine the reasonable accommodation? Let me ask you about Casey Martin, because you obviously must have looked at this. What's the big deal? What's the big deal? Let him use the card.
Well, they
No.
say it could give
Takes
us
away
a new advantage. They were talking about, save the summertime where all the other players have to walk and it's really hot and, they're getting dehydrated and they're having to, they can't get in the cart any more than if it were snowing or raining. So there is somewhat of a new advantage for him being able to use the cart to play golf.
The argument to that is this poor guy walks 10 feet, it feels like he just walked an 18-hole course, so I mean, I agree, obviously, we need to make the accommodation, but the competitive aspect of it, plus the PGA and their special rules, because they're their own entity, go into what he deserves.
I didn't buy that the golf cart is a competitive advantage in light of the fact that on the senior tour where the
Right.
seniors are allowed to use it, most of them choose to walk even when it's hot out. So if the walking is the hardest part of the game, that's really where your focus comes into comes under duress, then why isn't everybody riding in the golf cart when they can ride the golf cart?
Okay.
Well, I think they made a good point that walking is really a substantive rule of the competition. I mean, having to walk in certain conditions, whether that, some people may find it therapeutic to walk to the next hole and some people find it exhausting. For someone who that plays a part of their game, for someone who doesn't have to do it,
Is that really part of the game, walking to the holes?
I think that would make someone fatigue, and I think
Well, why
when
don't we make them carry their bags then too?
That's why you have cat.
Right, why don't we really have an athletic event? Did you go tee the ball off, walk a little bit?
well, whatever the golfer was it I don't know if Palmer, it was somebody who said that it is a huge part of the game, that walking, and if one did not have to walk, it would make a substantial difference in his game. So I think
But why, I wonder? Most golfers who aren't playing the PGA, they're not walking either, right? They're in a cart. If the travel from shot to shot is important, then, and we really do want some type of endurance, then make them carry their own bags. Then it might be harder to walk between holes, no? Instead, we give them these expensive caddies, they get to leisurely walk without holding anything in the whole world up to the next tee. And this poor guy with a crippled leg just simply wants to be able to make money and play. And they certainly use carts at other opportunities, so what's the big deal? It seems to me that it's more built for TV than anything else, right? We don't want to see them jumping in the cart, driving around, screwing around the cart, and then getting out at the next spot. I mean, is really walking an essential part of the athletic contest? Or the other part of what they're saying too is, hey, this is our game. We should be able to make our own rules, shouldn't we? Or is that, well, why? Any other business could say the same thing too.
Traditionally, golf, they pride themselves on the tradition of the game. Like they don't like a lot of changes in golf. So when they're going way back, walking is the essential part of the game. And until carts came along, and the seniors use them and everything, but walking is a part of the competitive nature, and they're not very adaptive to change.
Well, as I understand golf, though, if they go on strict tradition, then the females aren't going to be golfing at that course. No blacks and probably no Catholics at a lot of courses too. So there are reasons why we have laws that say, no, at some point you got to stop discriminating. It's wrong. So, I mean, are they discriminating against him, or are you saying no, he's not otherwise qualified, or he is otherwise qualified because sure looks in college like he was a heck of a golfer, and now he's simply saying, give me a reasonable accommodation. I just can't walk like a lot of these other folks, because I will lose my leg. This is not, I'll lose my leg.
It's discrimination. Like you said, if each golfer had to carry their own bag, choose their own shots without any caddies, that was a major part of the game, and that's it. But like they're walking around, they're leisurely, don't have to do this, don't have to do that. They should allow him to take the cart, because walking at that level isn't part of the game. It's just
No, it doesn't seem to me that it's an essential part of the game we're asking to modify, and that's the question, is that are they a place, in essence, of public accommodation? That was their first line of defense, but if they're going to lose that argument, and I think they are, then the question is this reasonable, or does it alter the fundamental nature of the contest? Do you remember the Olympics? I think it was the last Summer Olympics. Is it the same guy that was on trial in South Africa for murder? The guy with the blade, carbon fiber blades. There was some real question whether he should be allowed to run with those, because they were saying he now had a competitive advantage because of the light nature of them and how they could spring, that he was likely going to be faster than other people without those types of carbon fiber legs. Is it a competitive advantage, or is it miraculous that someone could still compete under those circumstances? I'm wondering whether you're going to say, well, that's an accommodation too. And how far down that road do we go? We're going to have wheelchair athletes playing in basketball?
Yes.
Because is that a reasonable accommodation? Should the professional sports leagues get to sort of opt out from this, so we don't have to make these accommodations? We are who we are. We're the NFL. We're the PGA.
That's why I wanted to go. I'm not sure that, are you going to have a wide receiver who's going to ride a cart down the field to catch the ball? I mean, at what point do you get to define the game in such a way where the athleticism is just a part of it, right? I mean, that's...
Well, but is this, see, this is my trouble, always been my trouble with this case. I'm not a golfer, as you probably have figured out already. If it's an essential, it doesn't seem like an essential part of the competition. I think it's much more for TV, frankly, myself. I think they want you to see them, because people watch this like all day. My brother-in-law will watch this stuff for hours and hours. He'll get up, when it's like overseas, he'll get up at 3 a.m. to watch golf. But it's built for TV, isn't it? It's so that you see them walking down the green and they're all quiet. But if we have someone screwing around with the cart, like I'm sure some of you guys do when you're out there golfing, certainly some of my friends do when they're out there golfing, That's just not as good TV, is it? So is it really, I guess that's what I'm wondering when I keep looking at this case, saying, essential part of the competition, or is this the lipstick on the pig that they're trying to make it look a lot better than it is, and or I guess it's still their game and they can decide what the rules are.
I'm also having a hard time buying that the walking is an essential part of the game, because then they've got this expert who says that the amount of walking that you do over the course, over the length of the golf course, burns about 500 calories spread over 5 hours. Which, I mean, I guess that'll make you a little bit tired. But as far as, you know, this injecting this element of fatigue into the game, I'm not a golfer, but I had a hard time buying it.
Well, those of you that are, I mean, is there real fatigue? Nick, come on. What? Well, Nick, you're pulling your cart though, even at least then, right? Or are you riding the cart and saying you get fatigued?
No, I mean, I've done both. I prefer the cart. In the middle of July, it gets hot. But, you know, when you're walking, you have to go up the hills, down the hills, and, you know, you're hitting out of sand traps, and you're getting frustrated, you're swearing to yourself, walking to the next hole, and it's as much mental doing the walking as it is physical. So you have so much time while you're walking to think about what you're doing.
But then that's an advantage for you, isn't it? To have that time to sort of think and work through your next shot and all the rest. He potentially doesn't have that same opportunity.
It's a disadvantage to me because I'm swearing at myself. I missed this. You know?
Well, let me ask you, I mean, you read the case. At the end of the day, we see where it goes. What about this McGinnis? What about this medical student? He just simply wants a reasonable accommodation because he can't pass, what was it, basic biology? Is that a problem for you?
Yes.
Well, why?
Well, because they also gave him many opportunities to retake this exam that he couldn't get more than, what, marginal, he needed substantial. He continued to take it, and he refused the help that he was given, and now he wants to claim, I'm just gonna drop out and not retake the first year over, and they violated the American Disability Act. So I have an issue with it.
Well, is he,
And they didn't, and they even said that they weren't, they said they claimed, he claimed that he has a disability. The court argued that this is not, they both agree that he has anxiety disorder when he takes chemistry and math tests.
me too.
Me too.
No, is that what it is though? Is that, okay, so we all have certain strengths, we all have certain weaknesses. Chemistry, math, that's why all of you guys are in law school, I assume.
And they gave him reasonable modifications, meaning to retake it under certain conditions if he wished to, and he chose not to. So I don't think that's really a strong.
Well, what's the major life activity that he says is affected by his disability in McGinnis? Can't learn? I mean, learning is a major life activity that the court would look at, right? By the way, it says grant summary judgment. What's the standard for summary judgment again?
No material facts rise to a tribal
No
level.
material facts
And your.
No material facts in dispute that rise to a material level. The moving parties entitled to judgment is a matter of law, right?
Yeah.
No material facts in dispute that rise to a tribal level. The moving parties entitled to judgment is a matter of law. That's what the court did here. The district court granted summary judgment on behalf of the institution. But, and as you already told me, it's that he experiences anxiety in chemistry and math courses in both graduate and undergraduate school. But developed some study habits that allowed him to overcome his difficulties. So what's, because it then talks to us about, it says, no qualified individual with a disability shall, by reason of such disability, be excluded from participation in or be denied the benefits of the services program activities of a public entity or be subject to discrimination. You guys talked about that. He has to, at some point though, show that he has a disability as the ADA defines it. And at this time it said, a qualified individual is someone with a disability who, with or without reasonable modifications, meets the essential eligibility requirements to receive the public services or participate in a program. physical or mental impairment that substantially limits one or more of the major life activities of the individual. However, the plain meaning of the word major requires that the activity be significant in order to be covered by the ADA. And then it says, major life activity, as you guys said, caring for oneself, performing manual tests, walking, seeing, hearing, speaking, breathing, learning, and working. I mean, as initially constructed, it was very clear that it had to be a significant and major life activity, such as the ones that we just described. Would learning be a major life activity?
Yeah.
Okay. Because, well, it says it right there, at least in the code of the regs would recognize it. Can he learn?
Yes.
Yes.
Yeah.
But he says he can't learn this stuff.
Can't learn chemistry and physics.
But it says it's also able to mitigate his anxiety in chemistry and math by altering study habits, so he can do it.
And the court.
Go ahead.
Said he must demonstrate that his anxiety impedes his performance in a broad variety of disciplines, not just chemistry and physics.
So tell me about that, so that, you know, I haven't taken it, but is con law a difficult subject?
Yeah.
Do you guys tend to have anxiety about that exam?
Yeah, Redneck will put the fear in you.
So is that, it would, I mean, could you say, Professor, I need a waiver from this con law requirement, because I have anxiety about it. Professor Rednick is very, very mean, and Malaguti's not much better. So my doctor says it would really be bad for my health to take this class. I want-
I was thinking maybe
Everyone
we do
just
that.
admitted that it gives them anxiety.
So if it gives everyone anxiety, tough luck? No, is that,
Well, I mean, I guess so, because it's not, I mean, it's so bad that it's affecting everybody, it's not just one person.
so some things are just difficult.
Yeah, for everybody.
Even if you have a disability, then no accommodation. I mean, suppose we can prove the disability. Nope, tough luck. You're not gonna, you can't wait, no requirement to waive an essential criteria of eligibility, because it says otherwise qualified individual too. I mean, do you really want him not passing, what course is it, chemistry?
Yeah.
Biochemistry?
In medical.
As a doctor? I mean, because that's a little scary, isn't it? Well, should you know con law as a lawyer? Should you at least know about the Constitution?
Yeah.
So, we're not gonna waive either, even if you can show some disability? Or what about that, do you get any? Not, isn't there language somewhere here, not everyone gets to be a lawyer, not everyone gets to be a doctor. You can learn, and by the way, everyone's learned already, because you must have a college degree, but you just can't learn law, you just can't learn bioscience, you just can't learn rocket science. Tough luck. Find something you can learn. You're out. Is it that? Do medical schools have to make reasonable accommodation? Law schools? Go ahead.
Well, then
Either one of you guys.
I was just gonna say that they offered him test-taking accommodations, I think, and I know that this school does, and I imagine most schools do, and he said he didn't need them. So really, the accommodation that he was asking for was after he had failed the test, asking to not have to take it again.
He wants a waiver, right? He
Yes.
wants a waiver of what I would think the medical school would see as a core requirement for, and I think most of us would agree that, at least from that would seem like a pretty legitimate core requirement. Like, to me, con law would be, what else would you, well, I'd say all the core requirements I think legitimately are, but certainly con law, it's hard to disagree that you shouldn't know about the Constitution if you're gonna be a lawyer. And I know it can be difficult, of course. Is that an unreasonable accommodation? You guys were saying, well, they were prepared to give him time, not just time, they were prepared to
Give a makeup test.
give him makeup tests, let him, the way I read it, almost keep taking the test till he could pass. And he said, no, I'm done, I want out, and I'm suing. That's not I mean, what, was the school offering him in a reasonable accommodation because I'm wondering now, after having read this case and seeing how they dismiss it, his claims, whether the law school, whether the medical school would have had to do anything for him. I mean, because there's language here, even if Mr. McGinnis had shown a disability under the ADA, he could not demand an unreasonable accommodation from the medical school. Educational institutions are accorded deference with regard to the level of competency needed for an academic degree. He wants a substantial rather than a reasonable accommodation, even if. And waiving a course, I think it gets into what someone should have, the core requirements someone should have in order to be able to work in that area. Would anyone make the accommodation for him? Because he's not disabled, or it's not a reasonable accommodation? Both. Do you all agree it's both? I mean, he can learn, he just can't learn. I mean, physics is hard. Is physics one of the ones he had problems with? Physics is hard. You know, there's some high-level math courses that you say, oh my God. It's worse than a foreign language. You'll see it on the board and it doesn't even look like English.
Well, if you're gonna take those classes and you expect to be a doctor or a lawyer or whatever, and the reasonable accommodation would be to keep taking the test until you know it, until you pass it. Because if they start letting people in that don't know what they're doing, then down the road, the profession's gonna hurt, the people that they treat are gonna hurt. It's just bad news to let these people that don't know what they're doing somehow get their doctorate or whatever, become a doctor.
It would seem dangerous. It seemed like almost, how are they gonna tell the patient the doctor's limitations? Because it would seem to a lawyer there should be some disclosure if you really don't know what the school said were core requirements.
It seems like an unreasonable modification to me, or accommodation to me, because it sort of substantially changes what this education is.
Well, I'm wondering, what about you guys? Whether that impacts you then? The way Chris said it, I'm wondering, well, how is that fair to those of you that do not have a disability? Okay, we'll waive you out of con law. We'll waive you out of anatomy, bioscience. Whoa. Or is that, no, that's fair's fair. Waive them out of these courses that are gonna ding us and require us to study twice as hard as we might for other courses, so. I mean, is that a consideration? Because I would think at some point when we get to the Toyota case, I mean, I do think there's some question about, they have concerns about how this is gonna impact everyone else working on the floor. And is that a legitimate consideration or not? Is from the school's perspective or from your view of this, no, the school shouldn't do it, others shouldn't be required to do it. At some point, it's not leveling the playing field, you're tipping the playing field decidedly in favor of someone else.
Well, it kind of comes down to almost public policy. I mean, we depend on attorneys and doctors to do the right thing, to be educated, to have been trained in these areas, because we're not, as the general public. And when you have these schools that are making these accommodations that aren't requiring that of different students, then where's the big deal? It's almost jeopardizing public policy, health and welfare.
Well, let me go further then with that. Firefighters tend to have to carry, pick whatever number you want it to be, for pounds. Well, with the disability I have in this arm, I can't carry quite that much.
Right.
Can you give me a waiver? Is that a reasonable accommodation?
Ride the truck.
Huh?
Be the driver.
Well, so I still get to be a firefighter, so I just don't have to go into the burning buildings? Because that sounds good with me too. No, I know I said it kidding around, but I'm serious. It seems mighty dangerous. I'd rather drive the truck. So I can still be a firefighter, get the better benefits, and I don't have to be exposed to the same danger as these guys? Because my guess is these guys at some point are going to say, what the hell? No?
Depends.
Or well, what do you think? Do I get to be, I can't pick up the 200 pounds and drag it 100 yards. I can do $1.50. We got a deal?
No.
Well, then maybe being a firefighter just isn't for you. Like, I almost feel like,
So that's not a reasonable accommodation, Elizabeth?
I just feel like I hated all science in college. And I knew that I was gonna suck at it, so I didn't pursue any career opportunities
Yep.
that involved
I hear you.
science or math because I knew that I wasn't gonna be able to get through it. And,
Geology.
So if
That's fun, actually.
going forward, I almost feel like, you know, they say he's otherwise intelligent, well then don't pursue this career. Like, and as frustrating as it is, if you're not gonna be good at it and you're not gonna be up to par with everyone else, you know, maybe you should start doing something else. I don't know.
No, you don't have to say I don't know. Is that unfair? I mean, I was actually liked and was very good at mathematics, but as you got to the top of level, seriously, the courses you were in saying, I really don't understand. And that was, and if I could get a waiver, instead of having to think I'm just stupid and lazy, I might have been able to complete the course there.
So would I, but I didn't get a waiver.
Right, well, is that just what it is? We're not all meant to be lawyers and doctors or rocket scientists or PhDs in math or whatever the hell it is. And asking for this waiver, this is not reasonable. A little more time, you know, whatever else you want to go. Well, let me ask you that. Let me ask you that from a lawyer's standpoint. I have a problem making deadlines. It takes me longer to get the papers done and to work through things. I'll just need an extra week or so in timing, and supported by a doctor. They will need an extension on the deadline simply because with the disability, it's harder to meet those deadlines. Anxiety and reading, whatever you want to call it. What do you think of that? Is that a reasonable accommodation? You're shaking your head. No. Why not?
Because there's so many things that you could do. I mean, you get a secretary, a paralegal that can help remind you of things. You could get an app on your phone that just pops up reminders all the time.
Start earlier.
What?
Stop the project earlier.
Right. I mean, there's people that have all kinds of disabilities. Like my dad is dyslexic and he operates just fine. You know, he does things on time, and I don't think
No, but
that's a
there.
good excuse.
So no extensions of time. No deadlines are deadlines in our business. That gets back to this. This is an essential item. You're not otherwise qualified if you are, by disability or otherwise, incapable of meeting deadlines. Is that true? Because are you going to get an accommodation on the statute of limitations?
No.
You're going to get an accommodation on the brief when it's supposed to be due?
No.
Yeah, maybe, but maybe not. Go ahead.
Like, by that point, you're already a lawyer. Like, you've already made it that far in your career, so you are capable of submitting things on time and passing in papers and assignments, so there's no reason why at that point.
Well,
you're like,
but what if the request comes here? The request starts here and says, this is what we need, is just, you know, we'll need time beyond the usual exam period, we'll need time beyond when papers are generally submitted, no more than a month. So while you're taking your exams in December, they'll be taking them sometime in January. Is that a reasonable accommodation, or are you guys saying, no?
Not for legal work, because you won't often get those extensions.
What about for medical school work? Would it be reasonable there?
Not for the ER.
Huh?
Not for the ER. Yeah.
Well, what about that? And that's what sometimes people say, well, like, there's different types of lawyers, there's different types of doctors, so should you have some type of blanket requirements like that? But aren't there, in whatever it is, well, is it essential that you lift 200 pounds, or at least can drag 200 pounds 100 yards in order to be a firefighter?
No.
Why not?
199, you know, what if you can only do 199?
What,
I mean, it depends.
I think that's good enough. I think
is
we
it?
passed-
Not you weigh 200, it isn't. Well, but is that what it is? But so if you're just, so 198 is just as fine as well. So where is your slippery slope then is the problem? And how come they all gotta carry 2 and I'm gonna have to carry 199?
It's being able to lift in general. I mean, if you can't lift something that's 80 pounds, I mean, you're not even close to the 200 pounds.
Well, is that what we have to do? Is that Chris's point as well? Okay, maybe 200 is too high, But is it, so can we pick a number and say, no, that's it? $1.75? $1.75? Jeez.
Well, if you're female, maybe it's 75.
Huh?
Maybe if you're a female firefighter, maybe it's 75. I mean, they do have different qualifications.
Okay, so when my house is burning, when I call, can I just say, please send the male firefighters? 'Cause- Oh, 'cause 75's not gonna do it, honey. You know, his $1.50's not gonna do it, at least.
Yeah.
No, but is,
So-
well, let me ask you that. Should both male and female firefighters have to meet that same standard as to what they're lugging out of that building then? Is that in sort of an essential core skill that there shouldn't be a waiver on for accommodations or otherwise? Well, they'll leave it at that. Yes, if you're gonna do that job, then you've gotta do what we all agree. So do we agree 150 pounds? Can you guys drag 150 pounds, 100 yards?
No.
But it's an essential.
So that's why you're not firefighters and you're in law school. No, is that what it is? So, so you're all in agreement, you won't be firefighters then? Because I would think that number, I hope that number is that, don't you think?
Well, is it, like with Casey Martin, he could play the game and he could play it well, but it was the walking ability, which really didn't impact the game per se, didn't impact how he hit the ball or how far it went. It was his disability prevented him from keeping up, but he could perform and he could do what was required to win the game if he needed to. And that's kind of what I think the disability definition is to try to create a level playing field so that people that have a genuine disability they can still do their job, but they just need a level playing field with everybody else to get there. It's not essential as far as what their duties are.
Okay, but so tell me though, would you make accommodations for someone who, because of a weakened side, cannot lift or move the same amount that the rules require? I can run just as fast, I can think, I can do everything else, but I can't possibly lift that 200 pounds and just even drag it 100 yards. I can do 150. Is that? And I can do a lot of other things much better than you. But that,
Is it an essential function? That's what.
It is.
Bottom line, you have to come down to that. If it's an essential function. then-
certain level of strength.
Yeah, I mean, if it's essential to the job. if
Well,
you-
what do you folks think it is? Because that's the question, is just because you make the rules, this is the first case. Just because you say you need a card, that doesn't make it essential because you say. Are there some medical school, law school, firefighters, police officers? I mean, I'd have trouble getting that target as often as you're supposed to. I don't see as well as they used to. So, would you still have to pass the same level of proficiency? Or close enough?
I'm okay with close.
Elizabeth shakes her head with the disgusting one. No, close enough isn't gonna do it, is
When you
it?
call the fire department and you have like 5 or 6 people in a house, they're called to run in and carry you if you're unconscious, and things like that. So I think strength is essential for a job like that.
So you're not making any accommodations in that area?
No.
Would-
I mean, maybe they could do something else, but I mean, as far as running in and, saving someone and not being able to carry someone, I feel like that's really
Couldn't
essential.
you still be a firefighter and not have to carry couldn't you
Yeah.
serve some capacity and not have to carry somebody 200 pounds?
Right.
Hey,
Well,
cook
I
in the
just-
firehouse,
yeah.
make the meals for all the guys.
but let me ask, because I'll come over, but let me ask you about that. So now you sort of get to pick and choose what your assignment's going to be because you have limitations? So yeah, okay, I mean, you don't see a problem with that? Oh, okay, so I'll run into the burning building and drag the people out. And you just worry about having dinner ready for us guys when we get back. You don't think that's gonna be, and we both make the same amount of money for this? Because I could see, come on, that's gonna be a problem.
It's essential that you can't, the average height of a male is 5'10" to 6 feet, from 175 pounds to 200 pounds. So the physical aptitude test, which I've taken for the state police, is that's your main job. You have to drag that dummy 50 yards, 100 yards.
Whatever,
If you
yeah.
can't do it, then, you sign that waiver before you start. You have to be able to lift this, do that, run that, carry this, carry that, or don't even apply. So you can't make special accommodations for people coming into the business, but if you got hurt on the job and you became disabled, then I could put you in as the firehouse chef or whatnot, because you got.
Yeah, I would say that, again, you were qualified, now you were injured in the line of duty, I think there's a different way in which we can work it, but getting in the door, it would seem that you need to have a core skill set that they and even we could agree on are essential. Whether, in fact, it comes to a challenge like Casey Martin says, well, that's not a core thing you need to do, and then we can debate it. I was coming up here, when you got, was it Nick?
I was gonna say, that's exactly the same point I was gonna make. It's different when you're going to apply for the job and have to meet all those requirements, and then say you get hurt in the line of duty, then you're like, all right, well, I guess I can't be a firefighter anymore. It's like, well, we can put you somewhere else until you either get better, or you can always cook dinner for us after you go out. But I mean, I think there's a difference between getting hurt in the line of duty after you've already been qualified, as opposed to not being qualified at all and trying to make adjustment to get the job in the first place.
Who's over here, either Stephen or Chris? No, we good? So, at the end of the day, does he get an accommodation or not? No, he gets no accommodation, right? They had concerns about whether he could even get past the first threshold about showing that he was in fact disabled, since he's been able to learn at every other level and in fact accommodate for some of his disability. And so he couldn't even meet the first hurdle. And then the second part, what he's asking them really isn't reasonable under the circumstances. Educational institutions are given a lot of latitude. If he can't pass this core requirement as the school sees it, then he's probably going to have to look somewhere else. And it is kind of an interesting case to think about from the standpoint of lawyering and you guys as lawyers. Would you have been better off telling him, well, just take the course again and be done with it? You know what I mean? You really don't think second time through you were able to accommodate your needs in the past by working harder and, you know, being sort of isolating yourself and studying. And instead we spend time in the district court where we lose, and then we take the case up on appeal. He spent some real time and money here. Would you have been better off telling him, I think you ought to go back and spend your time studying instead of litigating? I mean, I guess hindsight's 20/20, but wouldn't that have been a better use of his time and money than to think that you're likely going to be successful here? No? Would you tell your client to save the money instead of putting 50 to 100K in your pocket? Because that's likely what this did between the district court and the appeals. Because I would think he's probably pretty dissatisfied at this point. Spent a lot of money. He's gotten no further along. Frankly, he might be out of the medical school now at this point, since he didn't continue to stay there and pursue it. Would this have been a case that you should have told him, listen, kid, go back to school? Would you have?
Yeah, I would.
Would you?
Yeah.
He's willing to give you money to litigate in the district court, take the case up on appeal. There's some money to be made here.
I'm sure another case will walk in.
I think you have to disclaim and say, hey, look, if you want to go on a long shot, I mean, there's a shot, but it's a little one. If you want to pay for that, it's not probably the wisest money choice. But
Do you think he was told that it was a long shot at the outset?
Probably.
I would hope.
yeah.
Well, he does have a history of disabilities, right? I mean, it's not like he's a Johnny-come-lately to it, and I think sometimes the courts look at these cases and worry about that. That's why, like Natalie said, one of the standards they now look at is whether he has a history of being treated as disabled. And so it's not that he didn't, but they did really give him a relatively reasonable, it appears to me, fix on this. He just simply could repeat the first year curriculum. My guess, though, is that has to be quite taxing. You would think the first year medical school has to be pretty brutal, and if I wouldn't want to repeat it if I didn't have to and I guess he thought that somehow he could get them to waive this core requirement, which frankly, I think he's not likely to be able to do under any circumstances. Let's take a look at Toyota Manufacturing versus Williams. And again, you read the case, and it's another summary judgment case. And that's why it's important to really start to think about summary judgment, because in the real world, and you guys know the standard, we already talked about it, but in the real world, it really does become a pretty active testing motion, because plaintiffs and defendants use it to try and avoid the uncertainty of a jury trial. And oftentimes, in my experience in civil cases, it's only after the summary judgment motion is denied, or if you're fortunate enough to have it granted, if you're the plaintiff, that the other side becomes serious about trying to resolve it, because the concern about what a potential jury can do. The problem is it's usually pretty far into the process when the court starts to assess summary judgment. Also, you should know that in both federal court and state court here now, Massachusetts, moving for summary judgment is enormously burdensome. They request, you're required to file a rather large appendix with all your exhibits and uncontested facts and the facts that are contested. I mean, seriously, it's a monster of a job. It's the type of job you'd have to do if the case were going to trial at any rate. But it's a major piece of work that's enormously expensive, but obviously if you can be granted summary judgment, it's beneficial. And frankly, sometimes it's worth it to test it out. It also is a major prep for the trial, because you've got to sort through where specifically in the deposition certain information is that you want to now preserve and use. Because that's another thing I want to mention quickly is, lawyers in civil cases do a lot of discovery. We go out and do a lot of depositions, we gather a lot of information, we do production of documents, we have volumes and volumes and volumes of material. And a lot of lawyers don't digest it as well as they should. They don't keep track of where it all is and how they can access it quickly then for summary judgment and trial. And so you need to think about, after you've completed whatever the deposition or the request for production, you've got the information, you have to figure out how to manage all that data. And it becomes a big job, and not even in little cases it becomes a big job. But you got to do it, because you're going to need it for summary judgment, you're going to need it for trial. And I think some lawyers don't, because they figure, well, the farther we go, sooner or later this case will settle anyway, I don't need to assemble all of that. It's a sloppy way to go about it, because it'll settle for more if you know how strong your case is and you can prove it. It'll settle for more if you have a list of top 20 documents that you know help to establish a case. It'll also help you, to a much greater extent, be able to put a proper value on the case, to know how strong the case is for liability and damages. So don't just go out there. I've been to depositions where I can see the other lawyer just sitting there picking up his hundreds of dollars an hour to sit there and do nothing. And my guess is when that deposition comes back, it's going to sit in an office for the most part. When we get depositions back, we digest them, we make page and line references as where essential information is, and then that goes into some type of database so that we can access it quickly. And that's what you need to do with the information. You can't just sit on it and then when crunch time comes think you're going to be able to pull it all together. I've been brought into cases late where they are going to trial, and it's been ridiculous at times to try and now extract data that they've had a year or two that they've done zero with. And while the case is being tried, we're up to 4 a.m. in the morning trying to pull the information out. And it's just inexcusable. Do it while the downtimes come. But at any rate, we've got a summary judgment motion which is filed again and again. I call it a testing motion because in almost every civil case there's a motion for summary judgment. And what they're doing is testing the standard, but they're also testing the judge, because some judges are a lot more flexible with what they see that standard as, and whether they want to tie up their courtroom for 2 or 3 weeks with the trial. And if they grant summary judgment, they've cleared another case off their docket, and someone actually looks at that, at their clearing cases data, and they're also not tying up their courtroom for 3 weeks. And they figure half the times people aren't gonna appeal anyway. So the case may never get to the appeals court, so it's an easy way to dump a lot of civil cases. But she has a problem with carpal tunnel and tendonitis, and there's been problems with her working on the line. Says she shouldn't lift more than 20 pounds or engage in a constant repetitive movement with her arms, and overhead work she has problems with as well. They moved her around for various modified duties throughout the plant at times. And at some point, I'll say, I think they decided we had enough. We're gonna run our line the way we wanna run it. And Toyota then announced that they wanted all these employees to be able to rotate through all 4 of the process. And she says, I can't stand here like this for many hours of the day. Listen, who the hell would want to stand there like this for much of the day? My guess is, what time is it? Who knows what time it is? 5:27. My guess is, if I said we're gonna do that till 5:45, that we might not even make the next 18 minutes, okay? So she says, I can do the job, but I can't do all of these jobs that the line wants to, that you guys now want me to do. And as you can see, I'm disabled, so I want an accommodation, so I don't get this pain in my neck and shoulders. Does she get an accommodation? Well, why not? She got fired. So not just no accommodation, at this point now, she's terminated, and she goes to file her claim with the EEOC, Equal Employment Opportunity Commission. In Massachusetts, the federal government has that, and we also have the Mass Commission Against Discrimination, where the claims actually must be brought, for claims for discrimination must be filed with at least initially, with the MCAD. You can then dismiss it even before they hear it, but it must initial jurisdiction rests with the MCAD within 300 days of the discriminatory act. And don't think you should wait till 300 days, because it's an odd set of circumstances where the claim, you can only recover for damages that occur within the 300 days of filing the complaint. So by hesitating, you're actually losing some of your damages potentially on your discrimination claims in Massachusetts. So this Equal Employment Opportunity Commission, let me just tell you quickly, they're an arm of the federal government. They will investigate the claims, and it's not an adjudicative process, but after talking to witnesses and others and the individuals involved, they will issue a report, and they may even require corrective action and the like. While it isn't collateral estoppel, because it isn't adjudicative, these reports can obviously be very powerful and an ally in trying to advance your claims and the like, and to be able to put your case in a better position. The MCAD process, if you go through it completely, is adjudicative and then can have much greater weight. But an EEOC finding is significant if you can get it. So at any rate, and she filed her complaint and the like. She says she's disabled on the ground that they substantially limit her in manual tasks, housework, gardening, playing with the children, lifting, and working, all of which she argued constitute major life activities under the Act. Now this, I think this is one of the cases where Congress ultimately said, geez, the courts are really looking at our language and making it very restrictive. Let's ask what the Supreme Court does here. And in it's not Roman numeral, I think that's just regular 2, says, the ADA requires covered entities, including private employers, to provide reasonable accommodations to the known physical or mental limitations of an otherwise qualified individual with a disability who is an applicant or employee, unless such covered entity can demonstrate the accommodation would pose an undue hardship. Natalie's point about, well, how expensive is it? I'm not sure the bubble is gonna qualify, but there certainly will be others that, from a financial hardship standpoint, will absolutely qualify. She has an impairment. Is it an impairment that limits a major life activity? Because she can work, right? She just can't do all the work that this employer wants. Does that mean she loses? It does.
It does here. Yeah.
Because she can work, she just can't do what they want her to do, which is to do this for large amounts of time during the day. Does this seem harsh to you, or, I don't know, if it's part of the job and the employer needs the jobs done, it's a little difficult to run a shop if you get to take the two easy jobs, and now those guys then have to double up on this job that no one wants to do to begin with. I mean, is that partly sort of the underlying policy part of this, is that you just don't get to pick and choose which jobs for the employer you'll do, and you can't say, I won't do the more difficult ones, even if you have a legitimate impairment? Because I mean, you guys question whether she has an impairment? Because I did think there was a little bit of that here, that, well, maybe she's been loafing for a little bit, but I worry that that's always sort of a dig and an attack on this issue. Well, is it the employer is concerned about how they run their shop? Is it that, listen, it's as simple as she can work, she just can't do this work. We all don't get to be construction workers. We all don't get to do whatever it is for various reasons. If she can't do the manual tasks that are required here, but she can do other manual tasks, she's not disabled under the act, and therefore she's out. So manual tasks mean manual tasks, not I can't do this manual task. I can't do this. Frankly, I wonder how many people can do this for long periods of the day without developing some problem in their shoulders and upper.
That's kind of the problem I had with this, because I got the impression that if she was disabled, it was from doing that for so long. So that's different than applying for this job, but saying I can't raise my arms over my shoulders, or working in this job for a while and saying I can't do it. Now I've developed.
But if you've got that, then you've got workers' comp. Go out. If you
Right.
can, right? If you can no longer do the job, then there's a different remedy. It isn't necessarily the ADA. That's the employer's call at that point. It seems like a silly call if instead of having a workers' comp claim where you're now going to have to potentially cash this out and have the employee part ways, that if we can find something she can do that makes sense and continue to employ her and she likes to do the work and we don't have to worry about our insurance premiums skyrocketing. I think a little bit for Toyota is it's a policy decision in-house that we want to run our shop the way we want to run it, and you don't get to pick and choose which jobs you're going to get to do. I'd almost bet no one wants to do this job. It seems to me that that's a pain in the ass.
I also think she in her is a pain in the ass, because she.
Where'd you get that though? I do think there's I felt a little bit of that too, but why do we think that?
Well, I mean, 3 times she complains and she wants to file a suit, and then it's settled. And they give her reasonable accommodations more than one time prior to this one that we're discussing now.
Right.
And the parties, they say right here, parties agree that she is physically capable of performing both jobs, that her performance was satisfactory. So everybody that has to do these 1 and 2 jobs and these 3 and 4 jobs would all have a claim if she's arguing she has a claim, Yep. So I think that they're sick of her a little bit, and I think also that if she's capable of performing the jobs and now she's just pissed, like, no, I like the jobs that I've been doing better, her claim doesn't really have much merit. I feel like in and of itself she was just an issue.
So we're going to be done with her.
I'm done with her.
No, and so is the court. I mean,
Right.
I think the court pays they don't pay a lot of attention to her claims about being disqualified because she can't do manual tests, because they say, well, you can do some. And I do think Toyota at this point is saying, we want to run our shop the way we want to run our shop, and that's our right. And I think at the end of the day, the Supreme Court agrees that is your right. Let's take a look at this, the Waffle House case. It says the question presented is whether an agreement between an employer and an employee to arbitrate employment-related disputes bars the Equal Employment Opportunity Commission from pursuing victim-related specific judicial relief such as back pay, reinstatement, and damages in enforcement action alleged by the employers violated Title I with the ADA. Okay, first let me ask you that. So I can have an employment agreement with you that in that agreement you agree to arbitrate any and all disputes you have with us. And then that would mean you don't get to go to EEOC, you don't get to go to MCAD. If you've got a problem, you agree, we're gonna arbitrate this. No one's going to court or any agency, even for discrimination claims.
You are gonna go to the EEOC, even if we agree.
Well, can you?
Yeah.
I thought you agreed to arbitrate it.
Well, you make that with me, not with.
No, well, wait a minute though, this case is a slight twist on it, right? Just so we're clear, this case says, can the EEOC still come in and advance claims that it becomes aware of that might pertain to Natalie's claim for back pay and wages, or Chris's pay for the failure to receive an accommodation for which he was then terminated and he gets back pay. It's not whether you two get to go, it's whether I can go on your behalf. But see, I want to take the first question then first, because it's implied in the case then, because that's why they struggle with whether there's any bar on the EEOC from doing this. If you guys waive those claims, I don't waive them, but agree to arbitrate them, then you guys can't file those before an agency. Didn't you agree? Right?
Yeah, we can't.
You can't.
That's correct.
So would that be a pretty good idea then if I were representing an employer to have, no, seriously, right? Listen, do I have any of you, have you signed employment agreements? Have you read them?
No,
I haven't,
Huh?
no, I haven't read them.
You signed one and didn't read it?
They're really long, yeah.
Are you kidding? Yeah, get the hell out of here.
Take the pizza.
Listen, my daughter, who's 24, has had 3 different employment contracts in the last 2 years. Every one of them has these provisions and non-competes in them. Every employer is doing it now. I tell people, Michael, when he was 16, went to Circuit City one summer. He brought back a stack of documents like this that they expected him to sign so he could get 6 something an hour as a summer student up there. These provisions are in everyone's agreements. So I can, as a condition of employment, I can get you to waive even Americans with Disability Act claims and other discrimination claims and the like. Well, I don't mean waive, I mean agree not to advance them in other fora, but to take them through arbitration with me.
Yeah, the FFA would, yeah. With
Okay.
me, you can.
Okay, and the answer is yes, right? So tell me about, so you guys have signed those agreements. I'm feeling pretty good. Can the EEOC still come in on your behalf and bring person-specific claims, even though there's an arbitration agreement that would prohibit you guys from bringing those claims yourself?
yes.
Yes, right, that's what the case says. I think it's kind of interesting as to how that would come about. It would have to have a case with a pretty significant pool of people injured, because most of these agencies don't go out on their own and look for claims. That's what's a little unusual to me about it. And I think it would have to be, like one of these tip cases, something big where it's affecting a lot of people in a company, and potentially has a broader impact than that. The case makes reference to the FAA, which I think is important for you to understand, is that there is a federal act that broadly encourages the arbitration of disputes. Again, I think the theory behind it is it means less work for the courts. And so when you look at these statutes, what you're gonna find is that they would simply prefer you go somewhere else than use the federal government. And at the end of the day, even with the FAA in place, this case says, and this is pretty consistent with the law generally about who is bound by those arbitration provisions. If you're going to waive your right to access to the courts immediately, your signature should be on that agreement, right? I've even had them where it's the corporation has signed it. The president has signed it on behalf of the corporation. And they're trying to argue that not only did the president in signing that waive the company's claims or agreed to arbitrate, he agreed to arbitrate his own claims. And the argument being, he signed it Mike Coyne president, not Mike Coyne for himself as well. And so the courts, if there's a waiver of rights, if that's the argument, then the court should and does interpret that somewhat strictly, is that it should have been signed by you. I don't have the right to waive Stephen's claims and require him to arbitrate. And that's what's consistent with this case, if you think about it, is they're saying, okay, individuals, they can choose to agree to go arbitrate their own claims, but you can't restrict the right of EEOC or other interested parties, other interested entities who haven't signed those agreements from restricting their access to be able to pursue their regular legal remedies. And that's, at the end of the day, EEOC can go forward. It's an interesting case because I'm not sure how they would have otherwise, unless there's the case is going to have a broad impact, because usually they just simply would not be looking for additional work. I'm sure they were tipped off by one of the employees, and seeing such a clear case, they decided to go forward. As you look at the dissent, you've got Scalia and Thomas arguing that they should have all been bound, and that should be the end of the day. I just want to see if there's one other thing I wanted to mention. Oh, we're supposed to talk just quickly about remedies and domain name lawsuits, and I think this, and there's other things down the road where we'll look at it, but the reason we do it here is that if you have a website, within the agreement, when you took that name from the Network Solutions or GoDaddy or whoever you use to procure the name, there is an agreement within there for whatever disputes you have that you will be compelled to go through arbitration to resolve. And my point about that is for you to be aware of it. We'll talk a little more about website domain issues and the like later down the road. But what I want you to start to think about is that this forced arbitration, it's not forced because you don't have to sign it, but you won't get a website name if you don't. And you won't get purchases through Amazon or God knows who else that you're trying to do if you don't. But technically we don't need all that stuff, and that's the way the courts have started to look at it, is that whether you knew it was there or not, if you signed off on it or clicked I accept, you're going to be bound by it. And I think the theory behind it is that as long as you can't show that process is unfair, slanted decidedly in favor of the person who required you to sign it, they're going to enforce these provisions, and I think they do so because it means less work for the court. It also means a lot less uncertainty if we enforce the provision as to where you say it is, because transactions can take place God knows where right now. So I will see you guys Thursday when we do the next section, the business issues. So, thank you.
I know this may be a silly question, but for these cases, what are we trying to keep from them for the future? Do we want the regular rule of laws for them?